to Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BBI Law Group. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanti Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Illindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as legal advice. If you need specific legal advice, please contact attorneys directly. We will also be taking any general immigration questions along with today's topic. Hello Bhanu Garu, welcome to the show.
Thank you, Andy. Thank you very much for inviting me for the show.
Can you please provide our viewers with information on your law offices, practice areas and your expertise, please?
Sure. My name is Bhanu Babu Illindra, and you all know my name very well. I've been doing these shows for a few weeks now. My firm name is BBI Law Group PC. I founded this firm in 2008 January. Since then, I'm operating this firm. We exclusively practice in immigration law. We represent in all types of immigration matters, such as employment-based immigration, family-based immigration, EB-5 investor visas, F1 student issues, L1 visas. I mean, all types of immigration matters we represent exclusively at our law firm. You can visit our firm website, www.bbilawgroup.com, to get more details about our firm, what we do, how we do, and how efficient we are and everything. You'll be able to know that. If you have any questions about immigration matters, immigration issues, you can feel free to reach me to my office at 703-496-7722 to schedule an appointment. Or you can also reach me by email also, that is bhanu@bbilawgroup.com. Thank you very much, Andy, for giving me this opportunity to explain about my firm and about my practice. And I've been practicing immigration for more than 17 years now. It's almost 18 years now.
The pleasure is ours, Bhanu Garu. So we already have a caller on the show, Mr. Anil from Virginia. Thank you for calling, Mr. Anil. You may ask Mr. Bhanu your question directly.
Good morning, Bhanu Garu. Thank you for taking time today. Really appreciate being available. My question is,
it's my pleasure.
What is the time frame to switch the employer once we receive the green card? Is there any recommendation to move after 3 months or after or immediately? Do we foresee any issues in future if we move from the employer immediately after getting green card?
See, statute does not define any timeline. If somebody wants to move from an employer that actually sponsors your green card and you have been approved your green card, the test here is the totality of the circumstances and the reasonable standard test, right? What they look into is that whether there was a genuine offer of employment from the employer when they made that offer for you to hire permanently in the position which they're seeking or intending to hire you. And when they hired you for that position, they basically attesting to the fact to the USCIS that they're going to hire you permanently in the position, and the position is available to hire you permanently in their company for a full-time position, and you are also attesting to the fact that you intend to work for them permanently in the position offered upon getting your green card. However, things can change, circumstances can change. USC is very well aware of the realistic circumstances under those situations. Therefore, they did provide AC-21 portability regulations while cases pending also to move to a different employer for any reason with that employer. For example, if I have any disagreements with the sponsoring employer, or you got a better opportunity with another employer and your case is pending for 180 days, you can actually port. The reason why I'm talking about the portability, although it's not applicable here, is the same scenario, same guidance which has been provided for the portability can be considered if somebody moves from one employer to other employer upon them getting the green card. So it's about all the reasonable service standard test. You see, if you get a job, you get a green card, and you get a better opportunity once you get a green card, and you want to move, and if you move to a new job, I have not seen any problem raising for them during the naturalization process in my 18 years of experience, as long as they substantiate with proper evidence saying that they moved. Only reason is that they had a better opportunity, or employer actually, things have changed once the green card has come. Employer actually let you go in that position before you have to find a different employment. That is also another opportunity. So those are the things. So there is no certain time frame on that. In general, there's a common notion about in the immigrant community is that 6 months is a reasonable standard of time for them to move from one employer to other employer. That is actually incorrect, and such kind of a rationality is not supported by the USCIS. Even if you port after a month, after a few days of getting green card, as long as you can show there was a reason for one to leave an employment and move to a different employment once they got the green card within few days, they're absolutely fine. So don't worry, as long as that was a bona fide offer and you complied with the immigration regulations when you get a green card, and if you have a better opportunity to move to a new employer, you should be able to move to a new employer without any problem.
Right. I'm sure that answered his question, Bhanu Garu. So since we started off with the caller, I was thinking we can go on with the immigration updates. I was wondering if you have any.
As I said, there are not many updates this week, Hasni, especially the updates which I provide always based upon the employment-based category. I do not provide much updates on the family-based category in these shows because I believe that most of the audience who actually watch the show are interested in employment-based immigration. Therefore, I tend to speak more on the employment-based immigration. And accordingly, there are not many updates from the last week. We only know that the last update we received last week was about the visa retrogression dates. We discussed about that in length, and that's a major update which we have. And all other things are basically going on the same or similar basis. And that's all right now, Ms. Hasni. I'm sorry, I'm saying your name wrong. Sorry for that.
No, that's completely all right, Bhanu Garu. It's Torani. And let's get to the questions regarding H1B then. So how does the transferring of H1B visa work, Bhanu Garu? Could you please explain that to our viewers?
Yeah, sure. When somebody is on the US on H1B status and working for one employer, and if they find a different employer and they want to move to a different employer, the second employer is required to petition H1B transfer with the USCIS. And previously, prior to the AC-21 Act, when somebody leaves an employment and files an H1B petition to a new employer, they cannot immediately start working with that employer. They have to wait until that H1B was approved. However, this deficiency, that issue has created tremendous problems for the individuals because they left them without status in this country. And because of that, AC-21 Act has been enacted when they included the provision in the AC-21 Act, which is called H1B portability provision. That means if somebody moves from one employer to other employer, and if the transfer petition has been filed timely prior to the expiration of the status or prior to the expiration of the individual status, then employment authorization continues, and individual will be able to continue working for the second employer while such a transfer petition is pending. And now we all know that in 2016, the new regulations have been passed that came into effect in January 2017 also allows somebody to have a 60-day grace period if they get laid off from the job or if they resign from the job for whatever reason. They have a 60 days time frame to join a new employer, and if the employer timely files the transfer petition within those 60 days grace period, they're still authorized to continue work in this country while the transfer petition is pending. That is what the H1B transfer petition is. H1B transfer petition is, you always file it's actually a new petition filed by a new employer based upon the employment offer which they have. That's what it is. But this is the process which actually goes with the H1B transfer petition, Torni.
Right. Rightly pronounced, by the way. So, Bhanu Garu, my next question is, could you please explain to us the H1B Labor Condition application?
Okay, it's a very good question. Labor condition application is a prerequisite document the employer must obtain from the Department of Labor in order to file an H1B petition. What the requirements of the labor condition application is, the employer actually informs the Department of Labor through the labor condition form, that is form ATN 9035E, is that we have a H1B position. We are hiring a foreign individual based upon H1B visa category for a particular position, whether that position will be a software engineer or a lawyer, doctor, engineer, whatever position which qualifies as a specialty occupation in their company, and they will be actually paying the wages that are required to pay for the position which they are hiring him in the location where the individual is going to actually provide services. Why it is very, very important, the last part, what is stated in the situation is that based upon the location of the work where the beneficiary is going to actually provide services, the wage levels will determine, and wages will differ. For example, wages in New York and California are entirely different. The wages in California is different, the wages in New York are different, wages in Texas are different, wages in Seattle are different, based upon the standard of living, based upon the cost of living in that particular areas where the employee may likely reside or may likely work while providing services on H1B visa petition. Department of Labor actually sets the wages based upon the cost of living in a particular metropolitan statistical area or a particular city or a particular town or a particular county where the individual is actually going to work. So employers are required to pay at a minimum those prevailing wages or the pro-offered wages, whichever is higher to the employee in that location. So employer is going to actually attest to the fact that is hiring an individual on H1B visa category in a particular specific specialty occupation, and employee will be working at that work location where the position is located, and employer is going to pay the certain pro-offered wages to the employee for that position. That is the basic gist of that LC. Along with that, is actually attesting to the fact that is not going to discriminate H1B workers based upon their immigration status or anything like that. Is actually going to provide same working conditions what they usually provide to other US workers in their company, and other factors like, for example, if they're H1B dependent or not dependent, and all other attestations, whether they did, if they're H1B dependent, they have to do additional attestation saying that they did the recruitment to find a qualified US worker, or if they did not, or they did not replace any US worker within 90 days of hiring, or after 90 days of hiring H1B worker, those kind of attestations which they have to make, and they have to submit that application to the Department of Labor for their certification prior to the filing of an H1B petition. Once that LCA is certified, then USCIS, then the employer has to attach that labor condition application along with the form I-129 and its supplements and other supporting documents in order to seek H1B visa on behalf of the particular beneficiary whom they intend to hire in that particular pro-offered position.
Right.
So that's why LCA is a prerequisite document which the employer has to obtain from the Department of Labor prior to filing of an H1B petition. It's a very good question.
Thank you, Bhanu Garu. So, another most frequently asked question is about premium processing. While it's a known fact that a lot of people opt for premium processing, what we want to understand is if premium processing actually, in reality, does it increase the chances of approval? And if it's a myth, we'd love it if you could bust it.
The chances of increasing an approval while you file in premium processing is completely a myth. In order for the case to be approved, the case should meet the statutory requirements for the approval of the H1B petition, right? The application or petition which you're filing should meet all the requirements that are required for somebody to get a H1B status to be approved in the US. So as long as the petition meets those requirements, whether it's a premium processing or regular processing, the USCIS will exercise, that's my assumption, they usually exercise favorable discretion to approve that H1B petition. So filing in premium processing, likelihood increase the chance of approval is a myth. And it is not also the purpose of premium processing. The purpose of premium processing is to adjudicate your case within the certain time frame period, and for that reason, you're paying a fees to the USCIS to adjudicate your case expeditiously in certain period of time, that is within 15 calendar days, as of now, for the H1B premium processing.
Right, so I'm sure you've busted that myth for a lot of people watching this show, and we're glad you did so. So, my next question regarding H1B visas is, is it tough for certain jobs to get H1B visa in comparison to other jobs? I mean, are there certain kind of jobs that probably, for whom it's favorable or easier to get H1B visa? What's your opinion on it?
As I said, it's on a case-by-case basis. If the position for which you intend to hire an individual on H1B visa is a specialty occupation, then I don't see any issue for the H1Bs to be approved. Sometimes some certain positions by statute itself defined as a specialty occupation. Some of them are not. Some of them are based upon the position requirements may qualify as a specialty occupation. So you may have a difficulty on the later types of positions that if the requirements define whether the position qualifies as a specialty occupation, then it will be difficult. If it's generally, if the employer does not require a bachelor's degree at a minimum in a specific field of endeavor to hire an individual in the offered position, then that position may not qualify as a specialty occupation. I will give you a small example in the IT field. I do not, because it's easy, because many people from India in the US who are on H1B visa usually comes under the IT field. Therefore, I'm using this example because they can easily relate to what I'm talking about. Software engineer position do qualify as a specialty occupation because the position requirements clearly states that the employers usually require a bachelor's degree at a minimum in a specific specialty in order to hire for that particular position. Therefore, it qualifies as a specialty occupation, and it's easy to get an H1B petition for the software engineer position. But if you want to hire somebody as a web designer, which is also an IT field, or a web developer, which is also IT field that involves coding and everything just like software engineering, but web developer position do not qualify as a specialty occupation position because Department of Labor and other industrial standards clearly shows that usually employers, when hiring somebody as a web developers, they don't require the individual to possess a bachelor's degree or its equivalent at a minimum. If somebody has that, it's a plus for them, but it is not required at a minimum for the employers. So therefore, that position does not qualify as a specialty occupation. So you have to be very careful what positions you are trying to hire somebody on H1B visa. If somebody is trying to hire somebody on H1B visa, for example, like a position of a chef, then it's going to be a problem because chefs don't need, in order to become a chef, you don't need a bachelor's degree or its equivalent in some kind of a major, like a culinary arts, whatever it is, to become a chef in a restaurant or to become a chef in a restaurant. So those are the positions you have a difficulty in getting H1Bs. Most of the times, if the position defined as a specialty occupation statute, like a lawyers, engineers, doctors, mathematicians, teachers, most of the teachers may qualify as a specialty occupation individuals as long as the position requires bachelor's degree or equivalent. And these positions are easy to get H1B petitions than the other ones.
Right. So, Mr. Bhanu, is the perm labor certification required for all the employment-based green cards?
The perm labor certifications are required for the EB2 preference category. That means the EB2 preference category, which requires at a minimum advanced degree to provide services or to hire in that position. As we all know that in employment-based category, there are actually 5 preference categories. EB1, that is employment-based preference 1, and then we have 3 subdivisions, which is EB1A, EB1B, EB1C, and then you have EB2, employment-based preference category 2. That means higher in the hierarchy, highest is EB1, and the second highest is EB2. In them also you have 2 categories. One is advanced degree professional, and other one is NIW professional, that means national interest waiver professional, and EB3 category, where you have 3 subdivisions in them, which is professionals, skilled workers, and other workers, and then EB4, special immigrant visa petitions, and then EB5, which is an investor visa petition. These are the 5 categories you have in EB categories. In them, labor certifications are required for the advanced degree category in EB2 preference and all other 3 categories in EB3 preference, like a professional, skilled worker, and other workers. So these are the 2 categories you require labor certification, perm application in order to file I-140 petition. You do not need perm application to file national interest waiver I-140 petition in EB2 preference, or you don't need labor certification, that is perm application, for EB1 preference category as well. But for EB3 and EB2 advanced degree preference category petition, which is a regular petition, not a national interest waiver petition, requires perm ETA 9089.
Right. And Bhanu garu, what are the visa allotted numbers for each of these employment-based green cards? I mean, what are the allotted numbers for all of these?
It's totally 140,000 visas are allotted for the employment-based immigrant visas normally, and this 140,000 for all the nationals, individuals, not just for the India. In them, 7% of those 140,000 visas are allocated to Indian nationals. In the 7%, 2.5% was allocated to the EB1 category, EB2 category, EB3 category, and then 10,000 visas are allocated in that 7%. I mean, there are only not 10% basically. 2.5% to each category has been allotted in the EB1, EB2, EB3 category, and also 2.5%, 7% of 10,000. Actually, in 140,000, what happened is, this is how they have done. Okay, what they have done is 10,000 visas have been allocated to the EB5 category. 10,000 visas have been allocated to the special immigrant category, that is EB4 category. Remaining 130,000 visas have been allocated to EB1, EB2, and EB3 category. Okay, that is for all the nationals. In them, 7% of 130,000 visas will be allocated to the Indian nationals in EB1, EB2, EB3 category, 7% in EB5 category, and 7% in EB4 category. So that is the percentage is allotted to the Indian nationals in the employment-based category. Exact numbers, I think, will come around 10,600 visas, I believe.
Right. So,
not 10,000 visas, 7% of 140,000. So 7% of 140,000 is, yeah, 10,600 visas or 10,900 visas in a year. And in this 10,600 visas, it's just not only the principal immigrant, even his derivative beneficiaries are included in this. Like, for example, if you have a family of 4, if your green card is being approved, you are taking, and if 4 of them are actually seeking green card with you, you're taking 4 members into those 10,600 visas available to the Indian nationals in a year.
Right, right. So, Bhanu Garu, that was very informative, and we thank you for that. But moving on to my next question, this is another most frequently asked question, and I'm sure you've heard it a lot of times. It's about the USCIS processing times. And in regards to that, my question is, we've seen, it's a known fact that the Trump administration didn't, handle the USCIS immigration, times that well. So do you think there is a hope in the Biden administration for the processing times to probably decrease and, more efficient working around the visa times for all of the immigrants? Do you think this time it will be a different scenario?
I believe so. It's going to become better in coming days. Reason is that recently, one of the cases that has been filed in the federal court against the USCIS, the Nebraska Service Center director actually did provide an affidavit, actually stating to the fact that the processing times for the I-485 adjustment of status applications is going to be reduced from 21.5 months to 9.5 months in coming days. And he has laid down why it's going to happen, whatever reason and everything is. So that is from one service center director only, but that evidence has been submitted into the court. Therefore, I consider that to be valid affidavit or valid attestation by the director of the Nebraska Service Center. So accordingly, I'm assuming that it is expected that in all service centers, the dates are going to, the processing is going to improve for all the applications, and the processing times may reduce in all types of applications. We all know that the Congress actually intended USCIS to adjudicate many of these cases within 180-day time frame. But however, it is just an instructive guideline, but it's not something a mandatory guideline for the USCIS to follow. And based upon the several factors, USCIS can be very reasonable to take the time to adjudicate the petitions or the applications, but they are actually going through the process, and I'm very confident that there's going to be improvement in the processing times for many types of applications with the USCIS in coming days.
Right, and here's hoping to, that it will happen. And with that, we come to the end of the show. Bhanu Garu, thank you so much. It was a privilege hosting you. And once again, we thank you for all the wealth of information that you shared with us and our viewers.
It's my pleasure, and always enjoy doing the show with you and doing show with Sakshi. And I'm very thankful to Sakshi for giving this opportunity every week, and thank you all. Thank you.
We are too. Thank you, Bhanu Garu. You're watching Sakshi TV Live, and this is Tony Makana signing off. Thank you.